AR-15s and normal capacity magazines are quite literally on trial right now in Illinois. Yes, the Protect Illinois Communities Act is actually at trial. This video is me talking about that and showing how this is going to directly connect to the United States Supreme Court. We're going to be unpacking some of the government's biggest attacks in court against the Second Amendment, namely dangerous and unusual, as well as looking at are AR-15s protected by common use. Guys, buckle up. Let's get into it. All right, we're going to do the background super short. There are two blobs of lawsuits going through on this. One blob is going through basically the Northern District Court in Illinois. That's one that we've covered many times on this channel. However, this one we've only covered once, and that's because the judge, Mr. Stephen McGlynn, was actually the federal judge that ordered the injunction blocking the Protect Illinois Communities Act and was subsequently reversed by the Seventh Circuit. This wound up going up to the United States Supreme Court, who basically said, look, we're not going to get involved until this case is more settled and resolved. So the U.S. Supreme Court effectively put the goalposts up, and what do you know? Here we are doing a trial on it. Could this be going to the United States Supreme Court? It very well might, which is the reason why I am staying with it. For those of you who do not know, PICA, the Protect Illinois Communities Act, is effectively an old school style Clinton-esque assault weapons ban, AWB ban. Goes after AR-15s, AUGs, AKs, M1As, you name it, as well as it puts magazine restrictions, 11 rounds and up for rifles, 16 rounds and up for pistols. It does all sorts of different things. It's pretty bad. We've covered it many times before. Not going to keep covering it here. Just understand bad news bears. So in the opening statements for the plaintiffs, that's the good guys. Those are the people suing to go after this law. The attorney arguing, Mr. Andrew Lothson, said that the law should be ruled unconstitutional because it restricts access to weapons commonly used for lawful purposes. More on that in a moment. Now, the state is arguing through the Assistant Attorney General Christopher Wells that in their opening statement, weapons are primarily designed for use by the military and therefore are not protected under the Second Amendment. The government went on to argue that the state plans to call two expert witnesses with military backgrounds who will testify that AR-15 style semi-automatic rifles restricted under PICA are not materially different from the M16 rifles commonly used in the military, except for, of course, the fact that M16s have a selector switch that allows full automatic fire and in different modes, of course, burst fire for M4s and all that other kind of stuff. This is all fundamentally boiling down to 2 points. Are military-style weapons dangerous and unusual, which is effectively what the government is going to argue. Military-style weapons are too dangerous and unusual, therefore they are not protected under the Second Amendment. And then also we're going to talk about common use. We're going to talk about dangerous and unusual first. So I want to be emphatically clear up front. This is not what I believe. I am telling you what the U.S. Supreme Court has said. Please do not confuse those two. So the United States in the 2008 D.C. versus Heller case made it clear that in essence, look, there's going to be a class of weapons that are dangerous and unusual that are not protected by the Second Amendment. Quote, we also recognize another important limitation on the right to keep and carry arms. Miller said, that's the 1939 Miller case, as we have explained, writing in D.C. versus Heller, that the sorts of weapons protected were those in common use at the time. Okay, we're going to circle back around to that. We think that limitation is fairly supported by the historical tradition of prohibiting the carrying of dangerous and unusual weapons. The historical tradition of prohibiting the carrying of dangerous and unusual weapons. Okay. So what is the court talking about here? So the court cites to a really important historical writer, legal thinker, and commentator known as Blackstone, William Blackstone. It's the very first attribution in D.C. versus Heller. Very formative thinker who influenced the colonists, the early republic, the founding fathers generation, all of that kind of good stuff. So William Blackstone put together kind of a summary of English laws to include both statutory laws as well as common laws so that everybody can understand it. And he wrote a 4-volume work that virtually no one owns except me. This is volume 4. I have that one on my lap and in my hands because this is the particular quote that the United States Supreme Court is pulling from, and I will add every single anti-gun lawyer cites to. So Blackstone on this page writes about this particular statute from Northampton and about how it's dealing with this affray law of carrying a dangerous and unusual weapon. I'm going to go down to footnote number 27 because he does a great job of expanding on what is otherwise just a sentence or two, and he unpacks it more in detail. This offense existed at the common law, and the statute of Northampton was made in affirmance of the common law. The offense consists not so much in carrying a gun as in the wicked purpose and mischievous result of going about with that or any other dangerous weapon to terrify and alarm, and in such a manner as naturally will terrify and alarm. So that's pretty important. We're talking about dangerous and unusual. We're talking about terrify and alarm. And again, the United States Supreme Court is the one that said dangerous and unusual. And unusual. Underline that, put a pin into that. We're going to come back when we're talking about common weapons. My question for you is this: what do you think will happen as a result of this trial? What do you think the Seventh Circuit will do? And will this case, or will the Bianchi Maryland case, be the one that winds up going to the United States Supreme Court to deal with the so-called assault weapons bans once and for all? Don't forget to hit that like button. Now back to the video. So the question then arises of, how did courts wind up interpreting this law that was passed, keep in mind, during the early portion of the 1300s, all this time later? How did the colonists understand this? How did the founding fathers? How did the early republic? If only we had quotes I could show you in this video to unpack all that. Okay, so in 1686, a couple years before the Glorious Revolution and a couple years before the British Bill of Rights would officially enshrine, such as it was, the rights of Englishmen to bear arms, okay? There was something called the trial of Sir John Knight, and this is absolutely important. I'm not pulling this out of left field. This was cited by the United States Supreme Court and a whole lot of other people, as you will see. So Sir John Knight, trial again was in 1686. He loved to assist in the enforcement of England's statutes against Catholics. Keep in mind, Catholics, Protestants, they did not play nice in the 15th, 16th, and 17th centuries. This was definitely during one of those times. The Catholic Mass was actually illegal at the time, and Knight had broken up at least one secret Mass that was going on that we know of, thanks to historical notes. As a result, some Irish Catholics that were living in the English town of Bristol began looking for him so that they could kill him, is what historians think. One Sunday, Sir John Knight attended worship at his hometown Anglican church, St. Michael in Bristol, and brought a defensive gun. The government charged Sir John Knight, a prominent detractor of James II, so you can see how politics plays in all this kind of stuff here. This guy was basically anti-king, with violating the statute of Northampton because he allegedly, quote, did walk about the streets armed with guns, and that he went into the church of St. John Michael in Bristol in a time of divine service with a gun to terrify the king's subjects, end quote, or at least that was the allegation made against him. However, at trial, the judge explained the law. He said, quote, explained that the statute of Northampton had almost gone, warning, Latin inbound, desuetudinem, which effectively means that it's been lost due to disuse, which in and of itself is, of course, worthwhile to note. And the Chief Justice further explained that the act of going armed to terrify the king's subjects was a great offense at common law, and that the statute of Northampton is, quote, but an affirmance of that law, end quote. Thus, one's conduct will come within the act, in other words, would terrify the king's subjects, only, quote, when the crime shall appear to be malo animo, end quote. Apologies, I did not give you a Latin trigger warning. In other words, with evil intent or malice. So it's not enough to just carry the weapons. You must do so with evil intent or malice. Knight was ultimately acquitted by the jury because the jury did not think that Knight's peaceable defensive carry was with bad intent. Now, I mentioned that this case was a big deal. We know that the founding fathers and many colonists and Americans were aware of it, and this is what makes it so important, because this wasn't just something that happened in a vacuum, was a single data point, no one knew about it or cared about it. First, William Hawkins' Treatise of the Pleas of the Crown cited this case, Knight's case, for the exact moment, the exact data point that peaceable defensive carry of ordinary arms was definitively and unequivocally declared to be lawful. This work was also then published, the treatise, in England in 1716 and was followed by 8 editions through 1824. 8 editions. For those of you not into reading, not into publishing, that's a lot. That means a lot of people are consuming that. A lot of books, a lot of these things are being sold, bought, consumed, read, disseminated. Hawkins was, in fact, the leading criminal law treatise of the 18th century and widely used across the colonies in America. Hawkins' explanation that arms carrying was so prevalent was actually eventually cited by the Supreme Court of Tennessee in 1833. That's a case Simpson versus State. And by the Justice of the Peace manuals in the early Republic era in the United States. So again, big deal case that this would go ahead to inform this is how this particular statute, Northampton, is interpreted. This is how dangerous and unusual is interpreted and applied. No wonder why, at the time of the American founding, English law was very clear, quote, "Everyone is at liberty to keep or carry a gun if he does not use it for the destruction of game," end quote, as Edward Christian wrote in his 1794 annotated edition of Blackstone, going back to William Blackstone, because again, Blackstone, very important. And this wasn't even a singular case. As we've talked about on this channel before, in 1819, following widespread civil unrest, British Parliament had enacted a temporary statute against seditious armed assemblies in several counties. The law was upheld against a constitutional challenge because it did not violate the right to carry firearms for self-defense. According to one court, quote, "A man has a clear right to protect himself when he is going singly or in a small party upon the road where he is traveling or going for the ordinary purposes of business," end quote, but not to carry arms in a manner that is, quote, "calculated to produce terror and alarm," end quote. That's Rex versus Dewhurst. So once more, we see this incredibly important conjunction of it's not just the weapons. It's the weapons plus intent. It's the weapons plus the calculation to produce terror and alarm. That is what we are talking about historically. And historically is important because it's this history that frames the legal battlefield, that puts the legal goalposts up for the players, for the prosecution and the defense in this and every other case when we're talking about whether or not gun laws are going to be found to be constitutional or unconstitutional. Remember, we have the history and tradition test, where firearm laws and regulations must fit within our nation's history and tradition of laws, which is the reason why this is so incredibly important. Now, the statute of Northampton's was only rarely seen in criminal prosecutions, and it did remain on the books, for those of you who are interested, until its formal repeal in 1967. So Heller wrote, quote, that the sorts of weapons protected were those in common use at the time, end quote. There was no dangerous and unusual exception or limitation made when Heller wrote that. And why? Keep in mind, Heller said dangerous and unusual. And unusual. How can something be unusual, like an AR-15, if it's in common use? How can 24 million plus AR-15s not be in common use? I realize that numbers are difficult to wrap one's head around, so I always like to contextualize things. So get this. So in 2019, AR-15s accounted for over 25% of the firearms manufactured in the United States. Let's compare this to vehicle sales. I'm going to give you a few combinations. 25%, that would be the equivalent of, if you just went and looked at the new car sold statistics, that's every GM, so we're talking Chevy, GMC, Cadillac, plus every Mazda, plus every Tesla, plus every BMW, plus every Mercedes. That's all those car brands crammed together to equal 25%. Are those 5 car brands going to be considered together as in common use cars? Or that's every Toyota, Honda, and Mazda put together. Are those 3 car brands going to be considered to be in common use for vehicles? And I had to include the Ford guys there, even though I'm not one of them. That's every Ford plus Chrysler put together. All the Fords and Chryslers. Are Fords and Chryslers combined not in common use? That is what the government is going to be asking. So there's a little bit about dangerous and unusual, and a little bit about the common use test as it applies to this particular case. Of course, I didn't even touch on the fact that there are literally hundreds and hundreds of millions of qualifying magazines that, in essence, laws like this are seeking to ban. Keep in mind, the vast majority of the secondary market would be banned. So again, the common use stuff is ridiculous when we start talking about these sorts of things. I realize this gets more nuanced. We've covered it many times before because the antis will say that they are not weapons covered by the Second Amendment. They are accoutrements and are distinguished and separate from the Second Amendment. We've covered on this channel the checkerboard rulings that we've seen across the United States on that point. If you want to see me do a video kind of putting that all together, let me know in the comment section below. Otherwise, we're me closing out on our ever popular quote of the day. This one comes from one of the originals, one of the best, Emperor Marcus Aurelius from Rome, quote, "We have the power over our minds, not outside events. Realize this and you will find strength." Let me know what you guys think is going to come of this case. I am predicting a trial victory in Illinois, but then it's going to go up to the 7th Circuit where it's going to get, I'm sure, gutted, and then we will see where it winds up going from there. That's the very low, quick resolution take. I will see you in the comment section. I will see you in the next one. Don't forget to hit that like button. Thanks for sticking along. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.